welcome back to California Life Podcast. And today we have the living legend of the Californian legal system, Mr. David Foyil, and you are representing the company which we've been working together with for quite a bit of time. Thank you so much for coming to the show, first of all.
My pleasure, thank you.
We've heard a lot from Galina, who is here today with us, about you, and I've read quite a bit about your life story in this business. So before we dive into the actual stuff that you do, why did you decide to become an attorney? It's not an easy path.
Well, the joke in the legal industry is I couldn't do math, so I went to law school. So, but in reality, it's something that from an early age, I'm good at speaking, at communicating, at arguing, really. I mean, it really almost started when I was probably 7 or 8 years old, when I was arguing with my mom about something she wouldn't let me do. And she says, "You ought to be a lawyer because you love to argue." And from there, it just developed over time. I really am not joking aside, I'm really not a math or science kind of person. The law is interesting in that there is, you're taught in law school there's never a right or wrong answer. It is the art of argument, and you can find yourself on opposite sides of the same type of case at any point in time. And the goal is basically taking your client's position, as honestly and ethically as you can, pushing your client's case forward so that they can get the best possible result through the legal system as is possible. So it really is the idea of basically how can I take a particular set of facts and put together a case that presents my client in the best light possible. And so I enjoy doing that. It's challenging, absolutely. Sometimes it's difficult because it's a tough case, but every case has problems on both sides. So there's always a weakness the other side has, there's always a weakness our side has, there's always a strength on either side, and so you just have to maximize the strengths and minimize the weaknesses.
So it's some sort of a mind game, if I may.
Well, I don't know if mind game's a correct word. I think the legal system, what lawyers I think tend to forget in the legal system is that judges and juries are people.
Right.
People want to help other people. And so a big part of success in the courtroom is making your client likable to other people. Because even if you have a case that is difficult because of weaknesses that factually may exist in your case, a judge or a jury will, as much as they possibly can, look for a way to help somebody that they like and help somebody for whom they have sympathy or empathy. And so there's a lot of emotion that is involved. Theoretically, it's all supposed to be factual, but you have to interweave the emotion of your audience with the facts and help your client portray that.
Right. So it's a mind game with marketing and packaging and PR.
Okay. Probably, yeah. I mean, in non-lawyer terms, I would say that would not be an incorrect summation.
Right. You founded your company quite a bit of time ago.
Correct.
And you've been in the business for, please correct me if I'm wrong, over 3 decades.
No, about 29 years. So almost three
decades, yeah. What is the secret of your business success?
Well, there have been failures. There have been successes. And so business is not any different than any other aspect of life. When you miss the mark, you take a lesson from that. You learn what you can glean from mistakes. You try not to repeat those mistakes, and you do the same thing with successes. Things that turned out well. Examine it. What was right about this, and how can I replicate that? And so, it's always something to learn, no matter how long you're doing this. And probably with any business or any profession, it's always something new. And so being open-minded to the idea that I have more to learn and that I'm willing to accept self-correction or correction from others in order to make whatever it is we're doing better.
Did you have to work for someone else before starting your own company, or?
Well, yeah, my family didn't have any money to send me to school. And so when I was in law school, I worked full-time, and I went to school evenings. So it took a little bit longer to get through school. And then so the answer is, did I have to clerk or work in a law office? No, I worked in a call center for an insurance company. And very naively, I have to say that when I got out of law school, I thought I really had this thing down because I just spent all these years in school. And so I just started my practice. And that probably was the first mistake where I learned a hard lesson, because I discovered that what people learn in law school is very theoretical. There's very little practical application in terms of how you do certain things. So even getting paperwork into the court system in my first and second case was a real challenge, because I had never done that before, and it was something I had to learn. I started my practice in a small town, and the benefit of that was that the court was smaller and the clerks that worked there were very helpful. So they would, if I did checked a box wrong or filled out a form incorrectly or was missing a form or something like that, without having had the experience at that point in my career, they would kind of guide me through and help me get things up to what needed to be done correctly, so that when I was in front of the judge, I was all ready to go. So it would have been better had I worked for a law firm or a lawyer, and I just didn't really think it was necessary. But I got through it. I learned, fixed those mistakes, learned how to read books about how to do things that weren't available to us in law school. So,
well, I assume that was since it was quite a bit, time ago. Would you say that today it's more beneficial to open a business, any type of business, with the help of an attorney, a lawyer, or not? How does it work?
Well, I think it is very beneficial. And the primary reason, California is a very litigious state.
Right.
People are very inclined to begin litigation. And even business relationships with investors or partners can be have its ups and downs. That
right.
When businesses are very successful, there often is not a lot to question or be concerned about. When things are tight or tough, or you're at the beginning phase and there's a lot of investment money going in perhaps and no profit coming out, then people can tend to be a little bit more concerned about what's happening in the business. So those relationships really need to be guided by an agreement
right.
that is well documented, that sets forth what everybody's role is in the company, what the authority of each person is, what the management structure is going to look like, who is going to be investing, how much is going to be invested, what does that investment buy, what kind of a tax structure will the company be using, and toward that end, that often involves integration of maybe a tax advisor along with a legal advisor, to ensure that people have a good understanding of what that relationship is going to look like. The benefit of that primarily is designed to avoid being in court, to avoid having multiple attorneys involved down the road where people are challenging each other, and lawyers are very expensive and court is very expensive. So a good formation and setup is not inexpensive, but it can save tens, if not hundreds of thousands of dollars later if people have clarity in terms of what the business is going to look like moving at the beginning process and even through the first couple of years.
From your experience, when you'd say a client would come to you for an advice, they would want to start a company, versus all these online platforms which offer kind of the same services of starting a company, what is the benefit of working with a lawyer, with an actual person, versus setting it up online?
Well, a big part of being a lawyer is asking what-if questions. Part of my job is to think about what pitfalls may exist. What if this situation were to come up? What if that situation were to come up? What if somebody runs out of money and the business needs more investment dollars. What are you guys going to do? What's the plan?
Right.
What if marketing doesn't pan out the way you anticipate, and the revenues that you're projecting are not coming in? What is the plan? How are you going to tackle that problem? So online platforms are cookie cutter kind of things, and they work well in a cookie cutter situation that may not experience pitfalls. So the real goal of having an attorney involved up front is to dig in and ask questions. And I find typically, whether it's estate planning, whether it's a business formation, whatever the legal problem is, asking those questions, a significant amount of the time, the response I get is, I never thought about that. I don't know. And it's okay to say I don't know, because it's often a question that requires some thought, some planning, some analysis, some review of data, and it just hasn't been done yet, but it needs to be done. So the point is to get people engaged in terms of thinking about these kinds of things, so that we anticipate and resolve in advance what could go wrong.
Right. One of the concerns which people have when they decide to get into business is bankruptcy. Mm-hmm. And I know you have a lot of knowledge in this field. What is bankruptcy? I know there is a personal one in business. I might use the terms which are not exactly correct, but what does it mean? What are the consequences, and how does it work?
Well, bankruptcy is that's a big question. So business bankruptcy, it generally deals with the question of, what are we doing with the business? Is the goal to keep the business open and salvage it out of financial chaos and rescue it? Or are we done and we just need to wind things up? And if so, how are we going to do that effectively? So keep in mind, take a step back. A primary factor in business formation is setting up a business entity, whether it's a corporation, a limited liability company, a limited partnership, whatever it is. The California law allows all kinds of different formation processes. And the purpose of that is to separate individuals from the business, legally speaking, so that if the business becomes insolvent for some reason, the individual's personal assets are not at risk for the debt that is accrued by the business. That's the idea. And then to manage taxes the best way possible. So when we're talking about a business bankruptcy, we're generally not talking about the individuals, the investors, the partners, the managers, in terms of what they own as in their own names, but what does the business own? And so the bankruptcy law is divided into what are called different chapters. So in the business world, the primary alternatives are what are called Chapter 7, Chapter 11. Chapter 7 is basically a liquidation. We're done. We're closing the doors. We need all of our stuff liquidated. And the court will appoint a person to do that, called a trustee. And then the trustee becomes legally responsible to pay the bills that are owed by the business in an order set forth by law. So typically, for example, taxes or employees are going to get paid at the top of the list. Maybe secured creditors, if somebody has a lien or collateral, they're going to be higher on the list. If there's enough money left over after the liquidation, the people at the bottom may get paid something. Chapter 11 is designed to keep the business running. So we have a good thing going. We're in a tough spot. We can't pay our bills that are due right now, but we think going forward we can tackle the problem. We just need time. So in Chapter 11, it's a plan that is filed with the court that basically says, here's our process. This is what we're going to do to get enough money coming in so that we can pay people, and this is how we're going to pay people that will be different than the contract that we signed. And so the bankruptcy court has the legal authority to modify contracts and say, based again on priorities, this is how people are going to get paid based upon what the law declares their priority to be, and allows companies to reorganize the repayment of debt so that they can keep the doors open and keep the thing running. So that's the business side. The individual side, typically, in my experience, is I will say more often than not, it's really very conscientious people with a great deal of integrity. It's a common misconception that people that file bankruptcy are not responsible. In my experience, people that file bankruptcy are probably the most responsible clients I have. The reason they have debt is because they have demonstrated a lifetime of responsibility and have convinced people that because of their integrity that they're worthy of borrowing money. But something's wrong. They got sick. They lost their job, their business went bad, whatever. They're in a situation where they can't pay their bills that are due now. So from an individual standpoint, similar to a business, you can do a Chapter 7 and just start over. California law is very generous in terms of what assets people can keep in order to do that. Very rarely do people lose a home or cars or certainly not retirement plans or accounts. There are cases where there are assets that are not protected and they have to be liquidated or turned over to creditors, but it's pretty rare. I would say less than 5% in my experience does that happen. And even in those cases where there are assets at risk, the law does allow us to pre-plan the strategic reinvestment of some assets in order to ensure that they are protected. Whereas they may not be otherwise, and from also from a personal standpoint, it may be a situation where somebody just needs time. They just need to restructure. So, like a Chapter 11 for a business, an individual can do something called a Chapter 13, where they just put a repayment plan together and says, "I'm going to pay people. I just can't do it based on the contract terms. I need new terms so I can restructure this thing." So it is designed to be a protection, so people start over with something to start over on. That's what Congress has declared bankruptcy's intent to be. We as a society and a policy have determined through law that when people run into hard times and they can't pay their bills, that we all share through interest when we borrow money, that we're going to share the cost of those who run into tough times and can't pay it.
Right. You just mentioned about the protection of the assets, and I've learned that sometimes people would separate their assets, for example, their houses, under an LLC or a trust. How does it work, and what are the benefits of?
Well, that gets to be a really tricky situation, and so people, if you have questions about whether or not I should do any kind of modification or change to my assets because I'm having financial difficulty and I may need to file bankruptcy, you really have to talk to an attorney about that, because there are rules under the bankruptcy code that limit how that can be done. There are rules that limit when it can be done. So, for example, if I had a vehicle, an extra car that were not protected by law, which is rare, but let's say I had that, and you are my cousin, and I decide I have to file bankruptcy, so I'm like, I'm gonna give my truck to you, my car to you, and so when I own it, I file bankruptcy, it's not an issue. The law would allow up to a year, what's called a look-back period, and under the code, the person appointed to supervise that case on behalf of the Justice Department would be able to go to you and say, that truck should belong to the creditors of David. So you got to turn it over and give it back so that the trustee can sell it. So the formation of an LLC or some other entity is designed to separate assets of an individual from their business assets, so their personal assets are not at risk. But that's something you do at the beginning of the formation of a business. It's not something that you try to do at the last minute when you're already in financial trouble. There are ways that you may be able to accomplish moving assets, but the big problem with that is one of control. If you start moving assets into another entity over which you still have legal control, or otherwise control it, and the court's going to look at that as if it's you. It doesn't matter if it's got a different name or label on it, it's still your stuff, and it's still going to be subject to evaluation in terms of whether it's a protected or non-protected asset in a bankruptcy context.
Right. Sir, I know you have a pretty tight schedule. You just came from the court, and I assume you have another cases. So I do hope that we can continue our
Absolutely.
conversations on multiple other topics. And I know that you are also very active in terms of views on political development of the country. That's another side of yours, which I'm excited to learn about. Thank you so much for coming to the studio today. Thank you for sharing with our audience, and I'll be delighted to see you again.
Thank you.
Thank you, sir.